Good evening, everyone. We're going to go ahead and get started. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. For tonight's webinar, we're going to be discussing next steps if you are facing the prospect of a contentious divorce, and we were very grateful you were all able to attend. As a member of the Colorado community for over 25 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we try to provide to our community. A few points of quick housekeeping before we get started. If for any reason you lose your connection to the webinar or you have any other technical issues, you can email me directly at izzy@harrisfamilylaw.com and I will help you rejoin. Alternatively, if you have issues in the webinar, you can go ahead and throw those questions in the Q&A, and I'll do my best to help you there as well. Also in the Q&A, if you have any questions regarding the content of the webinar, please put them there as well. And we will try to get those answered by the end of the webinar. Excuse me. All right, now I would like to introduce our presenter today, Rich Harris. Rich is the managing partner of the Harris Law Firm and has been recognized by numerous legal organizations, including Best Lawyers in America in 2020, and has been a repeat selection to the Super Lawyers list for family law. He's also published many articles across a range of family law topics, as well as being the co-author of the Colorado Family Law Desk Book. Without further ado, I'll turn it over to you, Rich.
Well, thank you very much, Izzy, for that overly kind introduction. Thanks to each of you for joining us tonight. A couple of quick additional housekeeping points, if I might. Number one, to the extent that you hear any background noise, be it from kids, dogs, what have you, let me apologize in advance. Like many of you in this odd post-pandemic era, we're still working from remote locations occasionally. So if we're interrupted, we just plunge ahead, and I thank you for your patience. Secondly, on a bit of a more serious note, please note that I can't provide any legal advice this evening. It's simply beyond the scope of what I'm able to do, but hopefully the information that we're going to talk about will be practical, will be useful, at least in a general sense. As Izzy indicated, we're happy to answer questions the best we can, and we're of course happy to help beyond tonight for anybody who needs the assistance of an attorney. So again, thanks for joining us tonight. This is a difficult topic for so many of our clients, the issue of a contested divorce. I will tell you that I've devoted essentially my entire career in family law to helping people avoid contentious divorces, but we know, of course, that in many, many cases, it's not possible. So for those of you who are either in the midst of a contentious proceeding or perhaps you're anticipating that possibility, I'd like to offer some thoughts and some suggestions on how you can best protect yourself, your finances, and your kids. So we'll go ahead and get started then with the substance for tonight. First of all, by way of how we're going to organize the program. I'm going to start with a bit of an update in terms of what's going on in the family law courts right now. Then I thought it would be useful to present some global thoughts, some basic concepts with respect to family law, how the judges look at these cases. If you're feeling confused, don't get down on yourself. It's understandable. Hopefully you'll feel a little better after the talk tonight. Third, in terms of the guts of my remarks tonight, I'll be offering some concrete strategies on how to both prepare yourself for and deal in the midst of a contentious or contested or complex divorce proceeding. And after that, like Izzy mentioned, hopefully we'll have a bit of time for some Q&A. Okay, so I think it's really important for anybody that's either in the system now or is contemplating a case, or maybe you've just been served, There's some things about what's going on in the courts in the state of Colorado that I think it behooves you to be aware of. First of all, during the pandemic, and by during, I'm referring to from roughly late March of last year up until about a month ago, we had a very challenging time. And that period of time was made even more difficult by the fact that prior to the COVID-19 pandemic striking us, we're already in a very crowded court system in the state of Colorado. In particular, the metro Denver counties, where the attorneys and myself at our firm primarily focus. But this is true by and large across the state. Family law cases, including divorce and child custody and all the post-decree, meaning after the divorce or after the custody decree cases, those cases make up a large portion of all the civil filings in our courts. And it's a crowded system. It doesn't move along as efficiently or as quickly as certainly I would like to see. Certainly it's worse for those of you who are participants in the system. But then the pandemic hits, and what happens? First thing that happens is everybody's confused, doesn't know what to do. The courts essentially shut down completely for about 10 days, 2 weeks. Nothing was being heard. All of the administrators, the judges, the lawyers were all trying to figure out what to do. So you take a crowded system, then everything comes to a grinding halt. And 10 days in a system which is already way overburdened ends up being a pretty big deal. And now everything is backed up. What happened then was a sort of glorified triage system, if you will, where the courts were deciding which cases would be heard, and they were prioritizing what the judges deemed to be greatest priorities. Some of our common family law cases were not in that priority nature unless they involved domestic violence or child abuse, so everything got pushed back even further. Then, over the course of the next year plus, all of the court hearings, save for a small handful of very rural counties, were conducted either online via a video link like this one, oftentimes, by the way, not as good as this one, or even by telephone. That created a lot of impediments, a lot of challenges, not only for our clients, but for the judges in terms of how to handle this stuff. Things have gotten much better, of course, as time has gone on, and now, thank gosh, we're in an era where hopefully, fingers crossed, right? We're getting out of the danger zone with the pandemic, but how normal things are is going to vary from county to county. So, why is this relevant, especially for those of you in a contentious case or contemplating a contentious case? The reality is that family law cases, by and large, have a lot of built-in discretion for our judges. What that means is, unlike some other areas of law where things are really clear in black and white in terms of the statute says exactly what the findings are that a judge must make, and the rules are really rigid. In our practice, by contrast, the judges, we do have statutes and case law, of course, but the judges have a lot of authority, a lot of discretion on how to rule in the cases based on subjective factors. One of the most important of these is the credibility of a witness. And that witness could be you or your ex or your expert. If you're going to court and you're faced with a video hearing or a telephone hearing, which is still continuing for the foreseeable future in a lot of jurisdictions, in a lot of different family law proceedings, including, for example, temporary orders and divorces in some counties, your shot in front of the judge, your opportunity to convince a judge to do what you want him or her to do is a little bit different when you're doing it either by phone or over a video link. I, for one, think it is a lesser quality of justice. It requires a little more forethought and planning, and a lot more care. And the other piece of this is that if you're in a contested case, you're almost definitely going to require longer hearing time in front of a magistrate or a judge. If it's a simple, settled case, sometimes we're in and out of court in 10 or 15 minutes. For some of our complex and contested divorce cases, we might need a half a day, a full day, even a week or longer in front of a judge. The rule of thumb is that the longer the time is that you are requesting in front of a judge, the longer your delay is going to be in getting in front of that judge. It could be 2 months to get a 2-hour hearing. It could be 14 months for a full day hearing, depending on your county, depending on how crowded it is. So the advice I give always, and I believe wholeheartedly, is everyone in the family law court system should be doing their best to try and compromise, to try to settle outside of court. You have a lot more certainty about the outcome, and for the context of this discussion, you're going to get through the process a lot quicker. If you can't settle your case and you have to go in front of a judge, you have these built-in, sometimes long wait times, and that causes, most of the time, a lot more stress and a lot more confusion. So I wish I had better news there, but I wanted to make folks aware of that. That's an additional difficulty right now. Okay, so turning to some basic legal concepts, some family law concepts. We believe strongly that one of the best things that you can do to protect yourself is to understand as much as you can. You can have the best attorney on the planet, but it behooves you to still get some information on your own. We believe that knowledge is power. We believe that the more you know, the less stress you'll feel, and the clearer you're going to be in terms of planning your goals and planning your case. So there are some ways you can look up the family laws on your own at any time for free. First of all, anybody with an internet connection, and if you don't have one, you can go to the public library and get online. You can look at the statutes yourself, all of the family law statutes. They're arranged in numerical order. You want to navigate down first to Title 14, and then you go to subsection 10. What you're going to find there, and thank you, Izzy, for putting that info in the chat, what you're going to find there, is the Uniform Dissolution of Marriage Act, the UDMA. That is the body of law that governs almost everything in your divorce case. I recommend you look at it, take a look at the exact words that a judge that might someday be deciding your fate will be looking at. I think it's useful. Also, you can get some good information from the state of Colorado judicial website. It's a pretty darn good website, especially as far as government websites go. There's a lot of free information there, including downloadable free forms. Folks, don't let anybody try to sell you on a package of forms or a prepaid divorce. And, you know, I'm sure you've seen the commercials, heard the ads. There are a lot of large entities that are making money by selling people what's available for free at any time. Now, that doesn't mean that you have to use these forms, and these forms should be modified, especially if you have kids and especially if your case has nuance. But you're not going to be able to find any better forms through any third party than what you're going to get for free, the basic forms on state judicial. They're also linked from our website, our law firm's website, and we have a lot of, we think, useful information there as well. Hopefully you visited that site too. I recommend you take a look at it from time to time as issues come up, as you have questions. We have a lot of content there, and it's all searchable. Okay, so what are some of these big concepts that I think you ought to be aware of going into a divorce, certainly a contentious divorce? First of all, what is marital property? Well, marital property is all the property that you and your spouse own that is subject to being divided up by the family law judge. The marital property has a pretty broad definition, and basically it is everything that you or your spouse have acquired since the date you said I do, or, by the way, since your date of common law marriage. Common law marriage is still recognized in the state of Colorado. But anyway, all the property that you've gotten from the date of your marriage until the date of your divorce decree, no matter how it's titled, no matter what form it comes in, unless it was acquired by gift or by inheritance, such as a will, or it is excluded by a valid prenup, a prenuptial or postnuptial agreement that says something else about the property. Your takeaway should be the judge's assumption is that all the property is marital that you've acquired since the divorce. Excuse me, since the date of the marriage. If you want to prove something is not marital property, in other words, it's separate property, not subject to division, you have what's called the burden of proof. You have to bring to the judge the reasons why it fits into one of these categories. Like I said, it doesn't matter, and people are confused by this all the time. A car, a home, a retirement plan, if it's in one party's name or the other, that is not conclusive in terms of who owns it for the purposes of divorce law. All of that is going to be divided up. Secondly, even if you have separate property, the increase in value of that separate property from the date of the marriage until the date of the divorce, that increase in value, that portion of its value, is marital property and therefore subject to division. Another thing that trips people up is that the judge is required to determine value of all of the assets, and by the way, debts, as of the date of the divorce, not the date of the separation, the date of the divorce. We have folks that have been separated for months or even years, and they're surprised to learn that we're valuing things not as of the date of the breakup, but all the way through until the end of the divorce. And if it's a contested divorce, that takes many months. Some of them can even take years. Values, of course, go up and down, and the court is required to take a look at values on the final day of the marriage. Another important concept is the following. Marital property is not divided equally or half and half. In the state of Colorado, the judges are required to divide property equitably. Now, what is equitable division? Well, my flippant answer is I have no idea, having done this for 25, 30 years. The more accurate answer is judges have a lot of discretion, and so each judge presented with the same facts can divide things differently depending upon his or her own notion of equity or fairness. Okay, I will tell you that in all those years of experience, equitable generally means somewhere around 50-50, but that is not required as it would be in a community property state, which Colorado is not. Colorado is also a no-fault divorce state. So what that means, and this I think could have some special relevance for anybody in a contested situation, is that the reason for the breakup is irrelevant. Who did what? Who was the bad actor is irrelevant when it comes to dividing up the property. The courts instead are required to divide things equitably without regard to marital misconduct or fault. So what do judges look for then when dividing property? Well, one of the statutes, it's at 14-10-113. If you go to the link, you can read this statute yourself. It's called disposition of property. Here are some things that judges are required to look at. How much each spouse contributed. The economic situation of each spouse as of the divorce. If we're looking at the former marital residence, the marital home, the place where husband and wife live together, if they have kids, who gets the kids or where the kids primarily reside is a significant factor on to whom the marital home is awarded, and that's specifically in that statute. Next, alimony or maintenance. Alimony is exactly the same as maintenance. It's called maintenance in the state of Colorado. Maintenance is not required in every case, and it is only awarded after the property is all divided up. Only afterwards. So a lot of times what judges will do and what we lawyers will do for trying to avoid a maintenance order is we will give the downsided spouse a little more than 50% of all the marital property. So he or she has more to live on and therefore would not have the need for maintenance. So that's the main reason why the courts don't even look at maintenance until after the property is divided. And that's what I mean about an unequal division. If you're going to court and you're arguing for maintenance, that you need it, you can argue for that or a greater share of all the marital property in order to help you survive and hopefully thrive financially after the divorce. Okay. Kids issues. I'm going to vastly oversimplify this by saying that one of these discretionary terms I was referring to earlier is the best interests of the child. Most custody and visitation or parenting time decisions are based upon the best interests of the children. The judges are required to consider all of these factors I'm putting on this slide here, including what the parents want, what the kids want, the relationship of the kids with all of their caretakers and other meaningful parties in their life, mental and physical health of everyone involved, the history, especially the history of co-parenting, if any, where the folks live, meaning husband and wife after the divorce. And this last one is really critical. We do a whole separate webinar, and if you're interested, feel free to take a look at the archives. We'll do it again too on child custody cases, but I'm emphasizing more and more today than I ever have this last factor, and I think it's really important that those of you in a contentious proceeding be aware of. No matter how nasty things get, no matter how much you might have anger or perhaps worse towards your soon-to-be ex, it behooves you when you're arguing about the kids in front of a judge or in front of a child custody expert to make sure that you don't flippantly put down the other parent. You can express concerns about specific things about their parenting history or abilities, and you can express you wish they could improve, but it is important that you convey to a court, if you believe it, and hopefully you do, that in a perfect world, you want your kids to have a good and loving relationship with your ex. You know it's important to their development. You know it's important to their mental health. If you're found or determined to be the party that is alienating the other parent on the other extreme, the judge can and will penalize you. So please, please be careful on that issue. I throw this in because it's an issue that's near and dear to my heart. It's the reason I got into this practice, the reason why a lot of lawyers at our firm practice in this area. We care a great deal about kids. We know that kids in a contentious divorce can experience long-term fallout. Some of it is unexpected. Some of it comes, for example, in their future romantic relationships. It might cause future mental health or substance abuse issues in these children of divorce. What I can say is, if you're in a contested proceeding, what you can do to protect yourself and protect them, most importantly, is to shield them as much as possible. Don't put them in the middle. Don't go to them for comfort that's not appropriate. Keep them away from the direct conflict as much as you can. What we do know from a lot of longer term studies is that the damage kids suffer in a divorce is not just due to the fact of their breakup, of their parents' breakup, I should say, but the actual trauma during the breakup and the divorce is even worse. So please, please do all you can to shield your kids, and where necessary, get them help. Okay, so how do you then navigate a contentious divorce? So a few things to think about. If you haven't started the case, you're going to want to have key allies on your side, your team, if you will, people that you can count on. It could be a family member. It could be a friend. It could be clergy or a coworker. The point is, you're going to want to have somebody hopefully lined up in advance that knows you well, that knows what's going on, and hopefully can also be willing to take that call at 1 a.m. when you're in tears, or to come over to your house on a Sunday morning when you're at wit's end in anger or fear. And hopefully this person is not only a confidant, somebody who you can lean on, but hopefully can give you a little objective feedback. Sometimes a little tough love, a little perspective helps. I strongly recommend that you have that person or people lined up in advance. Then on the professional side, if you're in a contentious case, I highly recommend you make sure you get a qualified, experienced, settlement-oriented lawyer. Not every lawyer practices family law regularly. Not every family lawyer has a settlement-oriented approach. The lawyers with settlement-oriented approaches can and will still fight for you and litigate for you when that's necessary, but it's not going to be their first option because they know it's not the best option. Same goes for some other professionals that you ought to have in your pocket, if you will. A good financial advisor, a new one if you've used a joint financial advisor during the marriage, by the way, a therapist or a coach. These are all folks that can be very, very critical for you as you navigate the process. Okay, next. To the extent you can avoid it, you don't want to be fighting over paper during the divorce. Things are going to be stressful and confusing enough as it is without you having to scramble around to look for documents or information. I highly recommend that you do as much of this as you can in advance of the filing. It will help you a lot. It'll diminish the stress. It'll also, it'll save you money and time with all of your professionals, including your lawyer. Know where key original documents are. Make sure you have access to them. In a contentious divorce, bad things can and do happen. Awful, terrible things like people taking the kids out of the state or, gosh forbid, out of the country. For those of us who have handled cases like this, I will tell you there are some of the most painful and difficult cases that I've ever been involved in my career. Know where your passport is, know where the kid's passport is. Find the birth records, the birth certificate. Find your bank statements, your insurance statements. Get it all organized in advance, your tax returns, your pay stubs, your medical records, insurance. You're going to have to deal with something called mandatory disclosures in your divorce proceeding. It includes all this stuff and more, but this is all material that you're going to want to make sure that you have. It's not hidden, and that you can get to it in a way that is safe for you. Okay. I also recommend that if you're in a volatile relationship on the eve of a breakup, that you please consider the worst case scenario where in the middle of an awful confrontation, law enforcement is called, you're forced to vacate the home unexpectedly. It is always a good idea to know what's in your house. I recommend even going around from room to room with a phone and just videoing everything with some narration. just so you can document everything that is in your house right now. Okay. Next, become educated about your options. Just because you're in a contested proceeding doesn't mean that traditional litigation is your only way to resolve the dispute or to get through the case. There are other things that you can do and that you should consider, such as mediation. Mediation is a process where it's a settlement option with a third party neutral. Experienced lawyers can act as mediators. I do, for example. Mediation is often ordered by judges. We think it's a very good idea unless there's violence or some form of power imbalance. You should be proposing and trying your best to engage in mediation. There's also something called arbitration, which you have to agree to with the other party, but it allows either the mediator or another third party neutral to actually decide the issues in your case. And sometimes that can be a very good option if it's agreed upon, if you can afford it, especially right now with all the court delays, to not have to wait for a judge. There's also something called collaborative divorce. It's a process where everybody signs an agreement to engage in settlement conferences and not go to court, or they have to start all over again. It's an interesting process. It's very good for the right situation. Look into it and find out more if it's something you and your spouse can agree to. There's also something called unbundled legal services. It's a way of getting lawyer advice a la carte or on a piecemeal basis, if you will. It is something that you can pursue if you either can't afford a lawyer or you're choosing to represent yourself. You can essentially go in and buy the time of a lawyer for certain questions or certain portions of your case. Another word that I think bears mentioning for those of you in contested situations, if there's been any hint or any reality of violence in the relationship, either between you and your spouse, between anybody and the children, or anybody and the family pets, you should know that the time of filing and the time of going to court is a time where statistically these things can flare. I will tell you that one of the sad realities of the pandemic is that all the conditions for family strife, including domestic violence, have gotten worse. We've had more domestic violence. We've had more people in trouble. So if you're in one of these situations, think about it in advance. Get good advice before you file. Think about any threats to take the kids. Think about getting new passwords, a new private email account. Think about all of these things. What would you do with the pets if you unexpectedly had to move? These are all things to be aware of and very important right now. Some other cautions, okay? If you're on the eve of a difficult proceeding, don't make it even worse by trying to hide or get rid of or fake the value of any assets. It's almost always going to backfire, and it's almost always going to make a contentious situation even worse. I highly discourage you from doing anything like that. Another bad faith thing that people do, I guess sometimes it's not even in bad faith, it's just because people don't know, and I think I get that. If you're on the eve of a contentious case, don't take a lesser paying job. Don't quit your job and go into something that has far less prospects, or that gives you more free time because you think it's going to aid your chances in either a maintenance request, a property division, a child custody request. What you should know is that anything you do in the months leading up until your divorce can be second guessed, and it's going to be scrutinized. And if you do one of these things, the judge can often assume that it was done in bad faith and consider your situation as if it wasn't changed at all. So then you're in even a worse situation, potentially with less money, but the judge still making orders as if you had that prior level of money. Next, please, please, please don't discuss your legal proceedings on social media. The cat is out of the bag on this one, folks. We used to debate whether posts on social media could come into a courtroom. That issue has been put to bed conclusively. Posts from social media are introduced as evidence in courtrooms across this country every single day. Please, please don't say anything that could be taken out of context, or that makes you look in a bad light, or where you're deliberately or maliciously talking about your ex, or gosh forbid, a judge or an expert. I realize you're going through a tremendously stressful, confusing, often angering process. We get that. But this is what you should pick up the phone for and vent to that confidant that we talked about earlier. Don't put it out there online. It's always a bad idea. We talked about this. Don't disparage or put the other parent down, at least not to other people. The social media stuff, I am going to harp on it a little more. Again, it could come right into court. It can be taken out of context. What you think is funny and familiar, for those of you who have kids, I'm sure you've talked to your own kids about this. It never ceases to amaze me what otherwise very competent, mature, very successful people will do in the midst of a stressful family law proceeding. I don't judge it, it happens, but please be aware of it and try to avoid it. It will make things far worse. There's even a possibility that if you talk too much out of turn, that you're going to void your attorney-client privilege, and that opens a whole additional can of worms. You do not want to go there for sure. Your mental focus. This is so important. I think after working with literally hundreds of folks over the last couple of decades, that one of the biggest things that determine how people do in a case is how healthy they were mentally during the case and what they were focused on. Folks, you want to be strong. You want to have perspective. You want to think about the long term. You should recognize your limitations. Even if, in your calm, organized state, you think you could handle things on your own, maybe you could. Get some professional advice. Listen to your advisors. Allow others to put forth your interests, especially if you're feeling emotional or vindictive. Anytime you're letting your emotions determine your actions, you're probably hurting your case. You're probably causing yourself more stress than you need, and you're almost always going to be harming your children. It's stressful. It's confusing. Like I said, it can be angering. You're going to want to keep those emotions, to the extent possible, in conversations with confidants, or when you're by yourself, and you're going to want to take care of yourself so that when it comes to a hearing or it comes to an interview by a child custody evaluator or a mediation or settlement conference, that you can be focused and strong. A corollary to this is, I encourage you to keep in mind that the family courts are not in the business of picking winners and losers. They're not the place where you can go and get vindication, where a judge is going to agree with you that you were wronged, that yet your ex was a horrible scoundrel. Even if your ex was or is a horrible scoundrel, that's not what the purpose of the courts is. It's not what the judges do. And if you go into your case with that mentality, or you carry it forward, you're putting yourself out there for a huge disappointment and a lot of confusion along the way. Judges, family law judges, even the ones that are the most caring and experienced and patient, and folks, there are plenty of those, their job is to divide up property equitably. Their job is essentially, forgive this phrase, but they're dividing up kids based on best interests. This is supposed to be a dispassionate, calm kind of analysis. It's not a place where anybody is punished by and large. And that's kind of the underpinnings of no-fault divorce. That stuff about who did what is not relevant, and it's not going to affect property division at all. Keep yourself healthy and strong, always important. There's a few different things I think about when I think about health. I think about your mental health. Your mental health includes getting the rest you need, and being available and open to the possibility of settlement and compromise wherever you can, even if you have good reason to be angry or frustrated. Remember, your job is to protect yourself, protect your finances over the long term, protect your kids. So you have to do what you need to do to make compromises where they make sense. Okay? Take care of yourself. Eat well, sleep well, exercise. It's never going to be like it was prior to the proceeding, obviously. It's a stressful, difficult time. And so you need to be gentle with yourself, in my humble opinion. Do what you can. You're probably going to slip up. You're going to almost definitely have some late nights. You're going to have meals that are non-existent or they're junk. That's okay. Have some grace for yourself when you make some of these mistakes. Realize that you're going through a lot, and then take care of yourself. This might sound preachy or perhaps simplified, but again, what I'm telling you after 25 plus years of doing this, that people often overlook these simple things about taking care of themselves so that they can best get through a contested litigation situation. Get some mental mental health help for yourself, for your kids, where it's appropriate. It's almost always appropriate, in my humble opinion. There's no stigma. There should be no stigma. Again, you're helping yourself get through what is, for most people, one of the worst, most stressful things in their life. And that's before you even get to a contested, difficult case. So, finally, as we're running out of time here, some of these we've gone over before, some of these are a bit more. I believe that many people can and perhaps should represent themselves in court. It's possible, like we've talked about, the forms are available, they're free. You're allowed to represent yourself in court. However, if your case is complicated, meaning there are lots of assets, and or it's contested, meaning you and your spouse don't agree on who gets what, and or if you have kids at all, I'm going to highly suggest that good legal advice is paramount. Oftentimes, it's a wise investment. Shop around, choose well, get somebody who knows what they're doing, but get some help. Please don't rely on the word on the street. One of the things that I know from having done this a long time is everybody seems to know somebody who's been through a divorce, or either they've been through it, I should say, or they know somebody who has. Everybody is going to try and give you advice, and most of it is really well-intentioned. But please, please be careful. I can't tell you how often these things that are thrown around are just flat out false. Some of these assumptions that people bandy about are not reality. It behooves you to double check whatever you hear, not from your aunt, your dry cleaner, whoever it is. Again, well-intentioned as they may be, make sure you double check all of it. Take care of yourself. Try to stay positive. Try to minimize conflict. This might not be possible ever. I get it. But try your best. It's important. It's important for your health. It's important for your kids' health to do whatever you can. If all else fails, take things one day at a time. It's a cliche for sure, but take care of yourself. Document everything that's going on. Have a journal. What's going on with the kids, for example? What was said when? Have a dated journal so that you have a record of things. I don't know about you, but if I try to remember things and let it rattle around in my mind, that causes me stress. Realize you're in a very extraordinarily stressful situation. Document everything. Protect your kids always, almost at all costs. I say that with hesitation because that doesn't mean you give away the farm, and it doesn't mean that in the interest of avoiding a conflict, you're going to give up your rights to the kids or you're going to enter into a bad settlement. Please don't do one of those things. But if a good, healthy, sensible compromise is available, even if it's not the best that you might otherwise do, please, please consider it. It behooves you. Okay, so with that, I will turn it back over to Izzy for some Q&A. Izzy.
All right, thank you, Rich. We've got quite a few, so we'll just get right into it. Can you go, okay, so this is kind of a vague one. Can you describe how alimony payments work if the party paying alimony is close to retirement age or has changes in income related to health concerns?
Okay, so I'll try and repeat the questions. The questions go to how do you deal with a situation involving alimony where the party that's paying is either close to retirement or their income changes. Let me make it a bit broader because the same rules apply. In general, alimony, which like we talked about is the same as maintenance. You'll see the word maintenance in the Colorado statutes. The judges will talk about maintenance, not alimony, same exact thing. In terms of whether and how you change it, first of all, you need to take a look at the court order. The language of the court order often has the key in terms of whether and how the maintenance can be changed. Okay. In general, however, if the order is not specific, and let's say, for example, the order says husband is going to pay wife $1,500 per month on the first of each month until further court order. You want to come in and change it. Let's say you're the husband, you're nearing retirement. The law says that you can change the maintenance terms if there's a change in circumstance that is substantial and continuing, such that the original order is now unfair. So you can change it unless your orders say otherwise. In general, you can change for any reason where there's a significant change that's going to be ongoing. And it might be a loss of income, it might be retirement, it might be that one side loses their job. It could be on the other side that the recipient of the maintenance all of a sudden has a much greater need for the maintenance. Those are all reasons why a judge might consider a request to change maintenance.
All right, thank you. Okay, so this next one, my soon-to-be ex has a bunch of real estate in Mexico. If he doesn't show up for the hearing, can the judge do anything?
Okay, so the question involves property out of the state, in this case, in another country. What happens? How is that dealt with? And then the further nuances, what happens if somebody doesn't show up for court? Let me start with the second piece because it's a bit easier. Assuming the case has been properly filed and the other person has been properly served with the papers, if that served person doesn't show up for the final hearing, generally, in most cases, they will be deemed in default, and the case can proceed as long as the other procedural requirements are met. And in general, in those hearings, the party who is there testifies about what they want and why, and generally the judge is going to rule in their favor and enter a default judgment. Now, how do you deal with property that's outside of the state of Colorado or even outside of the United States? In general, judges can only order people to do things. They can't order banks to do things. They can't order insurance companies or employers to do things, or creditors. So if there's jurisdiction or there's power over husband and wife, a judge might order the wife, who, for example, has property in another country, to sign it over to the other spouse. The judge can make that order. But if the other spouse doesn't cooperate, isn't served, in general, the court is going to have a difficult time dealing with any property outside of the state of Colorado.
All right, thank you. Okay, regarding no-fault divorce and division of property and maintenance, is there any time where bringing up a spouse's spending marital funds on an affair would be a good idea?
Okay, great question, and one that often comes up in contentious cases. Thank you, questioner. The question is, it's no fault. Well, what about spending that could be considered fault related? So the short answer to that is yes, that might be relevant. So if you have, let's put aside the fact that it was spending for a new boyfriend or girlfriend or for an adulterous relationship. Let's just say in general, there is improper spending. Maybe it's for a gambling habit. Maybe it's for all sorts of other addictive behaviors. Maybe somebody is squandering the money or anything like that. Those are behaviors that you can introduce not to show that the other spouse is a bad person and that they should be penalized and given less. But we talked about there's that factor about, in terms of property division, the contribution of each spouse. The flip side of that argument is relevant. If somebody has squandered assets and been either deliberate or reckless with respect to joint money, whether they spent it on a boyfriend, girlfriend, or they spent it all up in Black Hawk casinos, you can bring that evidence to show that that spouse has diminished the marital estate and therefore should get less of the marital estate. Great question. Unfortunately, we're out of time. I'm going to need to end on that note. My apologies. As lawyers often do, I went on too long, but hopefully we've given you some good information. In closing tonight, before I turn it back over to Izzy, let me wish you all well. Take care of yourselves. Take care of your kids. And I wish you peace. Thanks so much for joining us, and have a good evening.
Thank you so much, Rich, and thank you all for attending this evening. As a thank you, we would like to offer you a free consultation. In order to schedule your free consultation, just give us a call at 303-622-5502 and give them the code WISER together when scheduling. And I will reiterate what Rich said. Thank you so much for attending. Please be safe. Take care of yourselves. Enjoy this beautiful Wednesday in Colorado, and we hope to see you at another webinar. Have a good evening, everyone.